Sometimes when we're setting up an escrow relationship for a licensor and a licensee, the question is posed whether my law firm or the law firm of the licensee could simply serve as the escrow agent in that case. Why should a law firm not be an appropriate organization to act as the escrow services provider in any given source code escrow relationship? Well, the answer is it's badly suited for providing those kinds of services for several important reasons. Ordinarily, when that question is asked, we're not asking in the abstract, could a law firm generally perform those services? Surely they could, but we're asking whether the licensor's law firm or the licensee's law firm could perform the services as escrow agent. Well, one of the reasons I don't like the term escrow agent is because that service provider is not really an agent of either party. It's not really tasked with authority to act on behalf of either agent in a binding fashion. It is a service provider, a vendor to the licensor or to both the licensor and the licensee. Law firms, by contrast, are in fact agents of their respective clients, and it's easy to understand that there could be a circumstance where the law firm has a conflict between acting in its capacity as the escrow services provider and acting in its capacity as the agent, the law firm of either the licensor or the licensee. As I've explained in another video, the trigger events for release of source code from escrow ordinarily occur either when there is some form of dispute between licensor or licensee, usually about whether support has been adequate, or at a time when the licensor is incapacitated due to bankruptcy or some other incident. In those occasions, the law firm of the licensor is really in a bad position to be acting as the escrow services provider, because doing so may be adverse to its client's interests. Likewise, the law firm of the licensee will have conflicts because its client will have a desire to obtain access to the source code even while a dispute arises. It doesn't want to wait to obtain support for the software, and so either law firm will be in a conflicted position. But there are other reasons as well, of course. Law firms maintain confidentiality all the time. They maintain client confidences, of course, and have many documents that are confidential for their clients. But law firms do not ordinarily have the heightened security that is available within many escrow service provider facilities. There may be biometric scanners, for example, at an escrow facility where no one has access to particular documents, let's say the source code in a deposit box, unless that person has passed through certain biometric scanners and his or her identity has been verified as an agent of the licensor. Let's say. And so the law firms don't always have the kind of security that's desirable in an escrow relationship. Law firms are also ill-equipped to perform some of the other services that many escrow service providers perform. In particular, escrow service providers, I use that term instead of agent, but escrow service providers often provide verification services. That is, they have teams of professionals who can assist the licensee in a confidential manner in assessing whether the materials that have been placed in deposit are all the materials that have been contractually promised to be placed into deposit. They will, for example, take the code that's in the box and compile it there within the facility and make sure that it all will work just as advertised in the license agreement or in the escrow agreement. Those kinds of services have great value to both licensor and licensee, and they are certainly not the kinds of services that most law firms can perform. So in general, I would say it is just ordinarily not a good idea for a law firm to play the role as escrow services provider related to source code, even though law firms can provide escrow services related to other kinds of documents, or sometimes with regard to payments in an M&A transaction, let's say. For source code escrow services, law firms are generally a bad idea. The reason I hear asked, as I mentioned to begin with, is often due to cost, but do bear in mind that escrow services have become less and less expensive as the market has found increasing competition and more providers of escrow services. And so there's never any reason that a licensor and licensee can't find an economical, secure approach to finding quality escrow services from a professional third-party escrow services provider.